Ladies and gentlemen, gentlemen and ladies, ladies and gents, just want to talk to you guys for a moment. We got some things to talk about. This is an arbitration confirmation or arbitration award. Let's find out exactly the title, because I so many documents, ladies and gentlemen. This is a case that was had, I think 2013 if I'm not mistaken, 2016. Okay, but we're gonna go all the way up here and get the title. Okay, petition to confirm arbitration award. Now, all of this information is just basic information about the arbitration association called FINRA. FINRA is the arbitration association. Let's see, FINRA, forgot what FINRA stand for. It's here, but I don't feel like dealing with FINRA, you know, because who cares what FINRA stands for? Y'all know what FINRA stands for? Asociación de Empleados del Estado Libre Asociado de Puerto Rico. Okay, the association, it's the Financial Industry Regulatory Authority, is FINRA. Financial, then IN for IN, then Regulatory Authority. Went over this earlier this morning. Alright, ladies and gentlemen, this was sent to me by one of the arbitrators. I don't think they realized what they had. They sent it to you, they must have realized it. Yes, they must have realized it, but let me point out some things that y'all need to know, because y'all really do need to know what's going on here. Whew, man. There's some case law here. We're going to share some of this case law with y'all. I want y'all, you going to put the document up? No, we're not going to put it up just yet. Y'all just going to have to hold on. Hold on, because I's coming. Okay, y'all just going to have to hold on, because I's tired. Y'all, I's tired. I mean, I really am tired. I'm exhausted. And because I'm exhaustedly tired, I can't promise you guys that I'm going to put this case law, this document up there, because it just ain't going to happen that way. Now I want y'all to pay attention. The final arbitration award and entry of final judgment in conformity with the final award pursuant to 9 U.S.C. 9 is the Federal Arbitration Act, subsection 9, which provides that a court must grant an order unless the award is vacated, modified, or corrected. The statute is unambiguous. The Supreme Court has explained there is nothing malleable, malleable about the must grant statement in the act. The court must grant such an order, which unequivocally tells the court to grant confirmation in all cases except when one is prescribed. One of the prescribed exceptions applies. That's why they have to look for a reason to get rid of the arbitration award. But other than that, they must conform the arbitration award. You feel me? You got me? You get it? You hold on to it. Because this is the Supreme Court of the United States that said this, y'all. When it says it must grant, the court does not have a choice. The First Circuit explained that arbitration's award are nearly impervious to judicial oversight. Judicial oversight means judge ain't got nothing to do with it. First Circuit Court said that. Bunch of idiots. Wait, what year did the First Circuit Court say that? Okay, I don't know, because that cow that's working there now, her name is Lynch. Okay, it ain't Sandra Lynch. That she was the Attorney General for a moment. It ain't Sandra Lynch. This is a whole, a slut, a cow, whatever she is. Okay, she worked her way to the top on her back for the most part. Sorry, I'm just stating the facts. Okay? The district court cannot vacate an arbitration award because it disagrees with the arbitrator's findings on the merits of the case, or because it believes the arbitrator made a factual or legal error. Doesn't matter. The parties agreed to the arbitrator. Doesn't matter if the arbitrator makes a factual or illegal error. Okay? It doesn't matter. Confirmation of an arbitration award is generally a summary, We want a summary judgment proceeding. that merely makes what already is final. Look, it makes what already is final, a final arbitration award, a judgment of the court. See, it's already final. Okay, let's go on because y'all need to understand what's going on here. This is what the courts have said. We ain't talking about what the attorney said. They're highlighting what the court said. I've been telling y'all this, and now we got the case law. So that's the end of that one. But we got one more because we got an actual court. The Supreme Court of the United States of New York. See, Supreme Court of the State of New York. This is the case right here in Nassau. Nassau, not Nassau, not Nassau, not Nassau, Nassau County. I'm kidding. I lived in New York for 5 years, 6 years, 7 years, and so I know Nassau County because I was always up there and going through there. Don't like it. Don't like it. To save your life, I don't like it. Nassau? Forget Nassau. Anyway, I didn't say NASA, I said Nassau. Now hold on, I want y'all to pay attention. An arbitration award may be vacated if it violates a strong public policy. Ladies and gentlemen, not true. This is a state arbitration award. The Federal Arbitration Award, Federal Arbitration Act, does not permit it to be vacated if it violates strong public policy. Is irrational. It's just got to shock the conscience. It's got to be unconscionable. Okay? Or clearly exceeds a specifically enumerated limitation on the arbitrator's powers. See, they were doing this under state law. They were not doing this under federal law. See, judicial review of an arbitrator's award is extremely limited. Judicial review of an arbitrator's award is extremely limited. And the court must accept the arbitrator's credibility determinations even if there is conflicting evidence and room for choice exists. Ladies and gentlemen, these are the facts. Now let's find out what else they say. This is the Supreme Court of the State of New York highlighting this stuff so y'all get it, because I done told y'all this is your way out, but nobody wants to pay attention to me. An arbitrator award should not be vacated for errors of law and facts committed by the arbitrator, and the court should not attempt to mold the award to conform to its sense of justice. The court ain't got nothing to do with it. Step away. Step away. Get your hands off of that. You ain't got no business touching that. Leave that case alone. That's what they saying. Y'all need to pay attention. Coinciding with this, the arbitration award is hereby confirmed in its entirety without modification. Do you see that, ladies and gentlemen? This is what the courts say about arbitration. Closing all these windows up. I have all this stuff open that I ain't supposed to be looking at no more today because I'm done for the day. It's 5 o'clock. I'm tired. I'm tired, y'all. I really mean I'm tired. So let me explain something to y'all so that y'all get it. I tried to tell you guys about Bradley Christopher Stark. I had some people going behind me and trying to check. Ladies and gentlemen, there is a lot of stuff going on, and I'm trying to keep it all together and trying to keep these organizations together, but I am just one man.
You ain't one man, you like 100 men. So don't be sitting up here trying to cut yourself short. You don't do that. Don't do that. We know better than that. You do stuff that the stuff you do, it probably take 5-15 people to do, but you do it and you do it lickety split like it ain't nothing, and then you'll be doing other things too. No, don't be sitting up here selling your okay, fine. I'm still tired. I'm being pulled at every angle, every end, and my biggest concern is you. You don't have to believe me. My actions should prove that. My biggest concern, talk to any one of the members of SATCOM, if you would only understand the amount of having to straighten things out, make sure that your interest comes first, because your interest is most important. We had an hour-long meeting last night with customer service on how they communicate with you. Okay? That was just with SATCOM. I'm tired because I spent all day thinking. What were you thinking about? Oh, I was, see, this is called thinking. Thicker, thicker, D-I-D-K-E-R. Thicker, 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 thicker. I was thinking. What were you thinking about?
Ladies and gentlemen, I was thinking about a new thing that I was getting ready to do. I'm going to share it with you guys, okay? We're not going to be doing this for you all. This is just my idea. I came up with this by myself. I had no help, okay? We're going to give y'all a copy of a bill, okay? You know, we talked about warrants. Didn't we do that yesterday? We talked about warrants. Y'all need to go back and look up what a warrant really is, y'all. A warrant is a check. A check is a warrant. Checking warrants, checking warrants, checking warrants. That's what it is. Checks and warrants. So, ladies and gentlemen, this is not the document. Come on, it deals with this document. This is it right here. I don't know why it ain't popping up. See, it still ain't popping up. Come on now. It ain't popping up. Look at that. It's frozen, y'all. Frozen in time. Frozen in time. Frozen in time. Frozen in time. It's the same parties, but it's frozen. Come on now. I gotta put y'all on pause because it's frozen. It wouldn't let me pause, y'all. Okay. We're gonna have to do, if it lets me, we gotta change the layout. Come on now. We're gonna change the orientation. Orientals. Orientation. This says in landscape. No, we can't do it that way neither. Alright, I tell you what, we're going to change the size. That's what we're going to do. Shut up. Nobody asked you. Change the size like I asked you to and get out of my way. I gotta do the orientation first to show it to y'all. Okay, now. Change the size. It won't let me change the size. Alright, let's see. I definitely got to pause y'all for a second. Y'all just gonna have to hold on 1 second, okay? Y'all just hold on, okay? If it lets me. Okay, ladies and gentlemen, I opened it up in the PDF Exchange. Now, give me 1 second. Gotta shut that down or it'll be typing up for days, and nobody wants that to happen. So now I gotta go back down here and make sure it didn't type anything in. Yeah, it couldn't type anything in because I ain't select nothing. But we gonna just talk about this just for a second. See, this is a bill. Because we got an arbitration award. It was for $60 million. So we gonna send Chase a bill. Okay, y'all understand me? They get to get a bill. See, amount due upon receipt, the date, and it says any forbearance is contingent upon your prompt attention to this matter. Any attempt to circumvent the process will result in automatic reassessment according to the terms of the agreement. Just that simple. Look at this. Harassment, failure to credit the account, violation of property rights, fraud, breach of agreement. That's an itemization of what the arbitrator decided. Now notice what this special notification. As you may be aware, an arbitration judgment award has been entered against you for the amount indicated. We know that these are difficult times. We sure do. Lord knows we knows. And we would like to make a payment arrangement with you. By law, you are liable for the amount plus fees, interest, and assessments. Please do not delay in responding, as this is an attempt to collect the debt, and any information obtained shall be utilized for that purpose. Now look, what get out of the way thicker than most.
we must also advise you that a lien may be placed on your assets as well as your properties, your wages, and or your company. Hold on, let's gotta put a comma here, because there should be a comma. Uh-oh, where you at? We can go here. Yeah, this is a different box, so this one, properties, comma, comma. Your assets may be garnished as permissible in law. You may wish to seek legal advice of an attorney or a competent person at law to assist you with this matter. Don't matter. You go get whomever you want. They gonna tell you the same thing the Supreme Court done said, and if they don't tell it to you, let me tell it to you. The Supreme Court has explained that there is nothing malleable about the word must grant. Must grant. It's not a must grant. It's they must do it. Ain't nothing to it but to do it. You know what I'm saying? Okay? Must grant, which is unequivocally telling the court to get off their anus and confirm the award in all cases except ones that are prescribed as exceptions under the Federal Arbitration Act. And then we put the other case laws here. And then with this we say the courts have held judicial review of an arbitrator's award is extremely limited, and the courts must accept the arbitrator's credibility determinations even where there is a conflicting evidence and room for choice exists. And then we put the traveling expenses and the cost of basic services. Okay, total plus legal fees and costs. $60,013,211.28. We ain't playing. This ain't no joke. Then what do? Well, we give them a cover my letter. Hold on, y'all. You see the cover my letter? Oh, there you go. Cover my letter. Cover my letter. Give me a second. I gotta readjust this thing because it's legal size here and then it's not legal size down there. So it's been doing that all day. 1 second, y'all. Be right back. I think I done fixed it. Y'all just gonna have to bear with us. There we go. Alright, now we're gonna do it down here, because I do it the other way, try to slide it by hand, it ain't gonna work. Now I want y'all to pay them attention, okay? Y'all need to understand, we write this letter to them. This is the cover page, okay? In the matter of arbitration between the following parties. They have two different addresses for Chase Bank. There's a payment address and there's a corporate address, okay? So we put the properties here, and then after we do a cease and a desist order. You are unlawfully demanding and or attempting to collect late fees and or payments in violation of the terms of the agreement and the arbitration award. You are hereby ordered. The properties have already been foreclosed on, people, and they still trying to collect money. You are hereby ordered to cease and desist from any further attempts at such collections. If you continue to ignore the terms of the agreement, the daily penalty rate will incur for each day since the entering of the agreement and the default of infraction. A request will be made to the arbitrator to adjust the award as a result of the calculations not previously taken into account by the arbitrator and is permitted via the Federal Arbitration Act 9 U.S.C. 1 through 16. 8th attempt, to whom it may concern. An arbitrator proceedings has determined that Chase Manhattan Bank is liable to the peoples of the peoples of the peoples and the EEON estate for the amount indicated in the award. Please know that this is an attempt to collect the debt, and any information obtained will be used for that purpose. Ain't this what they do to y'all? Well, we doing the same thing. Come on now, go slow. Can't go much slower because we need the whole award. Wait, please consider the following carefully, as you may wish to consult with an attorney for advice on how to proceed. We are willing to accept certified letters of credit. However, notification of payment must accompany the payment and is subject to approval. Now, there's the EEON Foundation, y'all. EEON Foundation. That's my logo. EEON Foundation. And pay attention.
Complete the following information.
Federal identification number, business name, name and address, and daytime phone number. And then what we do? We say the amount you're going to be putting. This is your remittance check. Come on now, pay attention, please.
Do not
Staple check to payment remittance coupon. You better not staple no check to this coupon. We ain't having that. Okay, hold on. Pay attention. Account numbers. These are the account numbers. Come on now. Current charges due. Total amount due. Past due status. Your account is currently in default status. Please bring the account current as soon as possible in order to avoid interest and other charges. Then please check this box if there has been an address change. There you go. And to the order of, and they pay to the order of. This is our bill that we send to them. Our bill. See, when I converted it to Word, this is what happened. Hold on, let me make sure this is going to do what it's supposed to do. Yeah, that's what we're looking for right there. That Supreme Court stuff. Okay, what we going to do with the Supreme Court stuff? Watch this. We got to go home. Take me home. Take me home. Take me home. Uh-oh. Uh-oh. I done messed up now. It said you ain't going home. It said you ain't correcting that. Well, anyway, ladies and gentlemen, that's the problem. What we've done is we've taken this little bus ride, and we didn't like being on the back of the bus, so we done came to the front of the bus, and we said, oh no, y'all ain't doing that to us. And they said, we're doing what? And we say, sitting up here playing us like we some fools. That's what we talking about. Y'all ain't doing that. And they said, we ain't playing you. And we said, you better believe you ain't gonna play us. And so what we doing? We getting them some Act Right juice. Y'all know what Act Right juice is. That's what we getting. Act Right juice. Gotta take that out of there because one more again. I said one more again. Come on now. Ladies and gentlemen, we're giving them a bill the same as they would give us a bill. The same as they would hand us a bill and tell us, you know, this is the way it's going to be and it ain't going to be no other way. We telling them, hey guys, here's your bill. Do you know why? Because when we go to the judge, we want to make sure that we prove that we've made an attempt. There is another reason why we are giving them a bill. I can't explain it to you because there's some information that is not privy for your knowledge. Just understand that if I'm giving them a bill, you should be giving them a bill. Do not ask me to provide you a copy of what I'm doing. What I'm doing ain't got nothing to do with you. Okay? But y'all don't understand me though. So I want to make sure y'all understand me. What I'm doing ain't got nothing to do with you. So get out of my business. Okay? People are asking me to provide them copies of the stuff that I got. No, it don't work like that. It didn't work like that last year, and it didn't work like that this year, and it ain't gonna work like that next year. It just don't work like that. Okay? I am not your huckleberry. Okay? That's not me. You got me confused. Okay? Go ask your mama. I done told her that I ain't your huckleberry. Alright? So stop sitting up here trying to make me your huckleberry. I ain't your huckleberry. Okay? It just ain't, it ain't that type of party. It wasn't that type of party last year, and it ain't gonna be that type of party tomorrow. Cause it just ain't that type of party. So stop it, peoples. It just ain't that type of party. Y'all just want to be partying all the time, like y'all Eddie Murphy or something, but it ain't that type of party. Okay? I'm not here to be your stupid huckleberry. You want a huckleberry? You better go get yourself your own hound. Okay, ladies and gentlemen, that ain't supposed to, I don't know what went on right there. That ain't supposed to be. We create the bill, and we create the bill for a reason. What's the reason you creating bills, bruh? Well, we're creating a bill because there has to be a bill. Yeah, there's got to be a Bob and a Jim and a Mary too, but you know, you still ain't telling me what's the reason because you don't need to know. That's what I'm telling you. So mind your own business and leave me alone. So we create the bill because the bill
is our evidence that we've made an attempt to collect on the debt, that we've given them an opportunity. The arbitration award is final, and in most cases they're in default of even the arbitrator, because the arbitrator sent them notice and they didn't respond, so they're in default. So ladies and gentlemen, we're creating a bill, and as I showed you, the Supreme Court, and the case law is in this document and in that case that we showed you, but as I mentioned to you, the Supreme Court has already made certain decisions, and it says, the law says that if you have an arbitration award, the court must grant confirmation of that award. Okay? Now what we're doing, and this is what SAA is doing, I said what we're doing. I just spoke with SAA because I handle the logistics of SAA. I don't work for SAA. I have nothing to do with SAA. I just make sure they have everything they need. I am the house nigga, a Negro. I ain't lying. I make sure SAA has everything they need. Okay, you need something? They say, yep, yells them, and I say, okay, what you need? And they say, I need you to get the get this and get that, and move this and move that, and change this and change that. And I say, sure enough, boss. And they say, alright. And I say, alright, and there it is. Okay. Ladies and gentlemen, all I can tell you, everybody's been worried about getting the arbitration award confirmed. I want to let you know, you don't want to get the arbitration award confirmed first. You want to go and try to get the debt first. You want to send a letter. You want to give them 30 days to respond to your letter. Okay? They don't respond, then you're going to send them another letter saying this is your final notice. The same stuff they do to you, you're going to do to them. It's your final notice. Okay? If you don't respond, then what I'm going to do is I'm going to put liens on all your properties. Everything you own. You guys know about that guy who put the lien on Bank of America? Go and look up the YouTube video and see what he did. He put a lien on Bank of America. Okay? And sure enough, Bank of America gave him what he wanted. So, when you have an arbitration award, a confirmation, go and put your lien on their property. They cannot tell you it's an illegal lien. It is 100% legal because the Supreme Court says that the arbitration award is binding on the parties. It's a legitimate debt. That's what the case law is there for, people. Alright. Do this video. I'm tired. That's why this video is so disjointed. So hopefully the information you got, you'll be able to get something out of it. But I'm exhausted. Too much work, people. Too much doing everything and not taking the time. So I've already taken my 2 sleeping pills just before doing this video. And I give it about another 40 minutes and it'll kick in. And I'm asleep. I'm gone. Ain't nobody bringing me back anytime soon, because I needs to get some rest. With that being said, I hope this information is of benefit to most of you. You'll be hearing more because we're going to be talking about the warrant issue a little bit more. We're going to be talking about sending out the bill. Remember, this all ties into each other. The warrant and the bill, I'm the warrant of the bill, farmer of Seville. Anyway, that's how this ties into each other. The warrant, the bill. That's what led me to thinking, wait a minute, what are we doing? Why are we sending them a debt collection letter? Why not just send them a bill, the same as they send us a bill? And why not give them a remittance coupon, the same as they send us a remittance coupon? So all I did was went online, looked up remittance coupon, and then looked up bill. Took it and put it in my PDF editor. Took me a while, but I created my own bill. I know, you want me to do the work for you, but I'm not going to, because that's not what I'm here for. Many of you guys want me to do work for you, and that's why I'm exhausted as I am, and that's why I'm getting more and more sick, because I'm not giving my body an opportunity to rest, my mind an opportunity to rest. So I'm not going to do the work for you anymore. I'll point you in the right direction. I don't mind doing that, but you're going to have to start doing some work yourself. Stop asking the organizations that I put together to do the work for you. They are not there for that. They are not there. We just had somebody saying that we're supposed to be explaining to them this and that. No, we're not. We told you guys that we're not going to do that. Too many of you guys are trying to duplicate what we're doing and you're messing things up for us. We can't do that for you. Okay, we told people this over a year ago. We put it up on the website that we're not doing that no more. But nobody's paying attention. Everybody, well, what about the QSIT number? What about this and what about that? Ladies and gentlemen, we already said that too many people have been messing up even with the QSIT numbers. We'll get the QSIT numbers soon enough, but we're not on the time frame with you guys for that. We will get that for you soon enough. We may or may not get it. Okay? Too many people are sitting up here demanding, talking about it's been too long. Ladies and gentlemen, all the stuff that we've been doing and all the stuff that we've been running into, it's not been too long. I promise you. If only you all knew. We're trying to fight off so much right now. So if you are a SAP packer, just understand that we've already placed an arbitration that deals with you. It hasn't been heard yet. Okay, so I can't talk about it, but it is against those agencies that are trying to stop us from fulfilling our obligations. What are our obligations? Our promise to ourselves that we would help add more to your packages. We didn't make that promise to you. We made that promise to ourselves. We said that we would provide that for you, but we told you it was no guarantee, as if we were Chico DeBarge. Oh, life holds no guarantee. Chico DeBarge? You don't know the guarantee song by Chico? Okay, you need to go listen to Chico. Chico, very good singer. Don't let the name fool you. Okay? All right, everybody. Have a good day. Have a good life. Have a good time. Adios.